The panelists who are on Zoom now, could you please turn on your video? Ladies and gentlemen, good afternoon or good morning. Thank you all for joining the second day of IFA APAC conference hosted by IFA Korea. For those of you who are new today, my name is Yeonu Lee from Kim In-chang, who will walk you through this webinar. Before moving on to today's sessions, I would first like to invite Mr. Kyung-gun Lee, Vice Chairman of the International Affairs Standing Committee of IFA Korea for opening remarks. Please welcome Mr. Lee.
Good afternoon, ladies and gentlemen. Let me first introduce myself. My name is Kyung-gun Lee, Vice Chairman of the International Affairs Standing Committee of IFA Korea. I'm currently working in a Korean law firm named Yulcheon LLC as a tax partner. Originally, today's opening remarks was supposed to be made by Mr. Jin-young Lee, chairman of our committee. But he cannot make it because he had some urgent work to be done by himself. Anyway, on behalf of IFA Korea, I'd like to extend my warmest welcome to all participants to this webinar today. Especially, I'd like to express my sincere gratitude to distinguished moderators, panel members, and speakers for their voluntary commitments to play an active role for our today's webinar. This afternoon, our webinar will cover session 3 and session 4. The title of session 3 is Recent Development of International Tax Dispute Cases in the APEC region. A number of tax experts have shown their keen interest in this topic, probably because these days international tax dispute cases are rapidly increasing in almost all countries. We expect that we can have a good understandings on the recent trend of tax disputes in the Asia Pacific regions through this topic, through this session. The session 4 of today's webinar will deal with issues relating to taxation on digital economy and U.S. countermeasures. Actually, this is a front burner issue around the world these days because OECD Inclusive Framework recently announced overall pictures of the new tax guidelines on the digitalized economy to be implemented in a few years. I believe that today's webinar would be quite informative and interesting to all audiences. Actually, more than 300 persons, not only from Korea or Asia Pacific region, but also from European countries, have signed up for this webinar. This fact demonstrates that our webinar's topics for yesterday and today are quite interesting and timely. At this juncture, I'd like to remind you that the IFA Korea, like all other IFA branches, is not a lobbying group, but a kind of a forum where all tax professionals, academicians, and tax officials gather together and exchange their views freely in a very constructive manner. In this context, I strongly believe that our discussions to be made in our conference today will be contributing to not only the development of the tax system of Asia Pacific countries, but also the enhancement of tax practices of multinational companies doing business in this region. Before closing, I'd like to announce that IFA Korea's another webinar focusing on international tax practices in Korea will be held on 28th and 29th of October this year. We'll circulate the details program for this webinar in the coming September. As you may know, IFA Korea has held this type of conference annually since 2019. Around the end of October in 2019, we had a face-to-face conference in Seoul. However, we had an untagged conference in November last year due to COVID-19 pandemic. Even though we'll have another untagged webinar this year, we plan to have a face-to-face offline conference in Seoul next year. Anyway, we hope that all participants of today's webinar can also join the IFA Korea's another webinar to be held on 28th and 29th of October this year. I look forward to seeing you in the coming October. Thank you very much for your attention. Thank you.
Thank you, Mr. Lee, for your welcoming words. Next, Mr. Ichwan Sukardi, Vice President of IFA APAC Region, would also kindly give us his accolade on today's webinar. Please welcome Mr. Sukardi.
Thank you, Ms. Secretary. Ladies and gentlemen, good afternoon or good morning, all participants and distinguished speakers or panelists. It is the end of the whole 2 days of the IFA Asia Pacific Conference organized by IFA Korea branch. On behalf of IFA Asia Pacific Executive Committee, I would like to congratulate to IFA Korea branch for organizing this event. It is a great event. You have brought not only a very recent and relevant topics, but you also, the organizing committee have picked also a very reputable speakers and analysts. My colleague Gunli has also shared that we have discussed various topics. Yesterday we had recent development of beneficial owner and general anti-avoidance rules in Asia Pacific, and I was also one of the panelists. And the session 2 discussing tax treatment of the transactional virtual assets. We are very excited that the all jurisdictions in the most of Asia Pacific IFA branch have participated in this discussion. And this coming discussion, today's session will cover also the very hot topics and very dynamic discussion on, as mentioned by my colleague, that tax dispute in cases in Asia Pacific. So this is the topic is, this topic has also been very, very challenging and very excited to also for all professionals, academics, also, of course, for the tax officer to compare and to learn from other countries how to resolve and how to take advantage from other jurisdictions experience. And the last one, I think this is very relevant and very recent topics which have been also shared by our IFA President, Mr. Claessen, the taxation of the digital economy. So I think this will be will close this webinar, and we are looking forward to this discussion. In this occasion, I would like also to thank to of course, to our IFA Central President, Mr. Mari Clason, for his opening remarks. Professor Pyong Bong Ah, IFA chairs, and also my colleague Kyung Gun Lee as Vice Chair of International Affairs Standing Committee of IFA Korea. And also my dear friend Kuntal De, the IFA Asia Pacific Chair, and also of course to all IFA Asia Pacific Executive Committee. And last one also highly appreciation and standing applause for IFA Korea Organizing Committee to say or organize such an incredible and very well organized event. IFA Asia Pacific is organizing a series of webinar. So though it is mostly independent one to another. So but it is I mean, we always encourage to also involve and extend the participants and also invite speakers or panelists from all over the jurisdiction, especially IFA Asia Pacific. This is the third IFA Asia Pacific webinar series. The first one is in Hong Kong, and the second one I think we had last month in India, and then follow in Japan. And I just heard from my colleague Lee that IFA Korea will also having another webinar in September. In relation to IFA a global conference, it is mentioned also by IFA president that some conferences have been postponed due to this pandemic situation. So IFA Global for this year will be postponed, and the next year hopefully we can have a physical event in Berlin and followed by Cancun, and 2024 in Cape Town, and then 2025 in Lisbon, and 2026 in Melbourne. So it is a long list. So if any jurisdiction is interesting to say nominate, then you have to go and register. So the IFA Asia Pacific itself will have the hopefully physical event next year in Hong Kong, following Japan and Malaysia, and 2025 hopefully we say meet in Jakarta or in Bali in Indonesia. So we do have, of course, the pandemic will be over in the next few months or in the next year, so that we can join the conference physically. So it is very good event to get in touch with all IFA members based on experience, so that we can exchange any experience. We can say have a social event, and then we can share our experience. Ladies and gentlemen, again, many thanks and highly appreciation to IFA Korea branch and organizing committee, and finally see you in the next IFA event. Thank you. Back to you, Secretary.
Thank you very much, Mr. Scardi, for your warm congratulatory remarks. As we are ahead of time, we'll start session 3 a little earlier than scheduled. Session 3 will deal with the recent development of international tax dispute cases in the APEC region. Moderator to session 3 is Mr. Jeremy Everett, a tax partner at Yulchon. Mr. Everett has been advising companies on tax matters for over 25 years, and he currently serves as co-chair of the AmCham CFO committee. For those who are participating via Zoom, you may find the link of presentation materials in the chat window. For those who are watching through YouTube, you will find the material on the right top side with download button. If you have any questions or comments, you can use Zoom chatting tool. The moderator will decide which ones to be addressed given the time frame. So let's start with session 3.
Good afternoon or morning. As was mentioned, I'm Jeremy Everett. I'm a colleague of Gyung-kun Lee at Yulchon, who I've known for many years. It's my privilege to be a moderator for this session, which I guarantee will be exciting. It's a little bit different from sessions 1 and 2 in that session 1 was, of course, on beneficial ownership and 2 on the tax treatment of digital assets, which are common themes throughout the region and, for that matter, the world. In our session, we've got a broad topic. We're looking at tax dispute cases, and that's our common thread, but we have very different tax disputes from jurisdiction to jurisdiction. So we'll be presenting today what I would call a tax dispute gourmet buffet. Now, that may sound delicious or it may cause guaranteed indigestion, but nonetheless, we have diverse topics which we hope you'll find interesting. Each of our panelists will highlight key landmark decisions in their respective jurisdictions, most of which they were directly involved with, and then they'll explain how these will likely affect the future. So you can see, as we advance to the next slide, the table of contents, some of the topics that we're going to talk about today. I note that we have more panelists than we had in either of the first 2 sessions. And so we have a lot of content to cover in limited time, and we're grateful to have the extra 5 minutes, hence we started a few minutes early. So we'll be talking about tax deferral in cross-border M&A transactions, the treatment of software royalties, rare transfer pricing decisions, court decisions, and cases addressing privilege and data privacy, which are, of course, very important in all of our jurisdictions. And then we'll also look at recent developments regarding mutual agreement procedures, or MAP. Again, that's a lot to cover, and so it's time for me to quickly turn my mic to mute and turn it over to the panelists, the first of whom is Tsuyoshi Ito. He's a partner at Nishimura and Asahi in Tokyo and a member of the firm's finance practice group. He's been recognized as one of the top attorneys in Japan, with recent recognition by the Legal 500. He has over 20 years of tax experience and has published numerous articles on Japanese tax. He also has significant experience in tax dispute resolution, M&A, and the formation of joint ventures and funds. Today, Tsuyoshi will be talking about tax developments, M&A tax developments in Japan, and specifically the Shionogi pharmaceutical case, which addresses qualifying for tax deferral benefits in an in-kind contribution of foreign assets and liabilities. So without further ado, I'll turn the mic over to Tsuyoshi.
Thank you, Jeremy. Today, I would like to talk about the Shionogi pharmaceutical case, which is a recent Japanese case in which Japanese cross-border taxation issues were litigated. This case is notable in that it involves a combined issue of tax-qualified business restructuring and pass-through entities. Please go to the first slide. Okay, first, I would like to start by explaining the relevant facts and backgrounds. Shionogi is a leading pharmaceutical company in Japan, and the first relevant transaction in this case back to 2001. Currently, Shionogi is operating their business in Japan, the US, and the EU, but in 2001, their business was primarily operated in Japan, and they had not yet begun researching and developing facilities outside of Japan. At that time, Shionogi was trying to develop drugs which would be in high demand in the US and the EU countries, such as therapeutical infection drugs, Alzheimer drugs, and anti-HIV drugs. They had detected a new compound which could be used in these drugs, but they did not have the resources or experience necessary to conduct clinical trials or apply for new drug approvals in the US or the EU. Just they were looking for a JV partner who could jointly develop these new drugs in the US and the EU, and soon identified a suitable JV partner. Thereafter, in 2001, Shionogi set up a Cayman Limited Partnership as a joint venture for developing new drugs with a JV partner outside Japan. Shionogi and the JV partner agreed to setting up a joint venture which would have a license for developing and marketing new drug candidates outside of Japan. They decided that Shionogi and JV partner would have 50-50 equal interest in the JV. They would bear the development cost equally, and they would set up a joint steering committee consisting of 3 members from each company. and which would have decision-making authority over the JV business. In 2007, Shionogi and the JV partner discovered new drug candidates for HIV and decided to develop these drugs using the JV framework. They conducted clinical trials outside of Japan and obtained a good clinical results. Just they proceed with new drug applications and prepare to launch the new HIV drugs. At this stage, the JV partner saw distribution rights for the new HIV drug. Before I continue, I'd like to provide some background information on HIV treatment. Under the current standard treatment for HIV, a patient is required to take 3 different medicines at the same time every day. Since the JV developed only one new drug, the JV was concerned that it might be difficult to sell a single new drug. It is also important to note that the JV partner is a pharmaceutical company which specialized in HIV drugs, and that they hold the right to obtain they hold the right to other existing HIV drugs. Just if the JV partner has sole distribution rights, they could make one tablet containing all 3 drugs, which greatly simplifies the medication procedure for HIV patients. After negotiation between the Shionogi and the JV partner, they agreed to restructuring the JV. Second slide, the final result of restructuring is that the JV partner obtained all interest in the share of Kema Limited partnership, and the Shionogi obtained 10% of the shares in the JV partner. In order to realize the final result, the restructuring was conducted in 2 steps. In the first step, Shionogi Japan made an in-kind contribution of an LP interest into a wholly owned UK subsidiary, SG Ltd UK, in exchange for shares of the UK subsidiary. At the same time, the UK subsidiary purchased the GP interest from Shionogi's US subsidiary. Please, next slide. Yes, then Shionogi's UK subsidiary made an in-kind contribution of LP and GP interest to the JV partner in exchange of 10% of the share of the JV partner. Shionogi Japan believed that the in-kind contribution of the LP interest by Shionogi Japan in the first step was tax qualified and just could enjoy tax deferral. However, the Japanese tax authority alleged that in-kind contribution by Shionogi Japan was not tax qualified. Next slide, please. I'd like to briefly explain which in-kind contributions are tax qualified under Japanese corporate tax income tax rules. In Japan, an in-kind contribution to a wholly owned subsidiary is generally tax qualified. However, in the context of cross-border transactions, a Japanese corporation needs to pay attention to exemptions. An in-kind contribution in which a Japanese corporation transfers Japanese property to a foreign subsidiary is not tax qualified, even in the case of a foreign owned subsidiary. Japanese property includes real estate in Japan, mining rights and stone cutting rights, and assets and liabilities belonging to domestic offices. It is important to note that assets and liabilities belonging to a foreign branch office are not recognized as a Japanese property. As you might know, Japanese income tax is imposed on the worldwide income of a taxpayer, and just Japanese corporations are required to include taxable income realized in the foreign branch offices. However, Japanese corporations are able to restructure foreign branch offices into a foreign-owned subsidiaries through a tax-qualified in-kind contribution, without triggering income tax obligations, although they should review the tax rules in the jurisdiction in which the relevant branch office is located. Next slide, please. In the Shionogi case, issue was whether the LP interest is a Japanese property, a property belonging to a domestic office of Shionogi, Japan. If the asset at issue was the stock of a foreign corporation, no issue would arise. Stocks for a corporation are assets which are different and separate from ownership titles of an asset held by the corporation itself. However, in the Shionogi case, the asset at issue was an LP interest in a limited partnership formed under the laws of Cayman Islands, which is a pass-through entity for Japanese tax purposes. In Japan, a pass-through partnership is an entity which is not separate from its partner, and partners of the partnership are treated as directly holding partnership properties in accordance with their proportionate share in the partnership. Yes, we can argue that the Shionogi Japan holds partnership interests through a partnership, much as if the headquarters of a Japanese corporation held such interests through a foreign branch office, and that an in-kind contribution of an LP interest should be treated as an in-kind contribution of partnership property, which do not constitute Japan's property. Next slide, please. In the end, Japanese courts agree with the Shionogi's argument. The courts first argued in regard to the scope of Japanese property and determined that an office to which the property belongs should be an office which ordinarily manages and administrates such property. Further, the courts discussed the nature of the partnership interests and argued that an interest in the self is fundamentally different from stock in a corporation and constitutes a status which is inevitably a combination of a partnership status and joint ownership in a partnership property. Just the courts rule that in deciding to which office interest in the self should belong, we should review the ordinary management and administration of partnership property itself, and that courts further found that offices of a JV partner outside of Japan managed and administrated the relevant partnership property. As a result, the courts decided that Shionogi's in-kind contribution was tax qualified. Since I think that I'm just about out of time, I would like to turn the microphone back over to Jeremy. Thank you very much for your time and attention.
Thank you. I mean, it's a very exciting case, and I can imagine that the taxpayer was excited about that. There's not much more shocking than when you plan on a tax deferral in an in-kind contribution or restructuring and then find out later in an audit that it doesn't qualify. So all's well that ends well. Tsuyoshi, if you're still there, I wonder if I could ask a couple questions, maybe briefly, because we've got a few minutes. In this case, is it common for foreign and Japanese companies to set up foreign JVs rather than Japanese JVs?
Yes, I think that depends on the business of the JV. This JV mainly performs the clinical research outside of the US, mainly in US and the EU countries. So they set up a partnership outside of Japan. But if the JV business relates to mainly performed in the Japan, usually they set up some Japanese entity in Japan. So I think it depends on it relates to the JV business where they set up some entity.
That makes good sense. I'm also wondering whether, in terms of precedent, whether there are other taxpayers out there with similar fact patterns or that have made in-kind contributions of assets that could be deemed as foreign assets that may be able to take advantage of the logic that was used in this decision to file refund claims. Does this case have value as in terms of precedent for other taxpayers?
Yeah, yes, I think so. This is in Japan, case judgment related to the limit partnership is a very few, and this is one of the important precedent in relation to the limited partnership. But I also note that this partnership is a joint venture. I mean that Shionogi and JV partners actively involved in the management of the JV itself. And if the limited partnership is something like funds, I mean the investor is a passive investor. In that case, we need to think about that this case have a scope. We need to discuss of the scope of this case judgment, I think.
Did you handle this case yourself?
Yes, yes, that's right.
So congratulations on the big win.
Thank you very much.
Well, thank you very much, Tsuyoshi. Our next panelist is Min-kyung Cho, who's actually sitting next to me here in Seoul. She's the Deputy Director of the International Tax Division of Korea's National Tax Service. She's a U.S. licensed attorney. Currently, she's in charge of OECD tax projects, including BEPS implementation and digital tax. So she could have been a panelist of any of our many panels and fit right in. So we're very glad that she joined us in our panel. She's in charge of the NTS's international tax initiatives with the US, Canada, and European countries, which is an enormous role. And she has a bachelor's and master's degree from Yonsei University's School of Law and an international law LLM from the Washington College of Law. Today, she'll be addressing recent developments in Korean MAP procedures and arbitration resulting from the completion of the OECD peer review process. So with that in mind, I'll turn the mic over to Min-kyung. Welcome.
Thank you. Hi, guys. My name is Min-kyung, and thank you for the kind introduction, Jeremy. Hello? Is it working now? Okay, we had a mic issue, which is common in the Zoom era of things these days. Hi, my name is Min-kyung, and I'm the Deputy Director of the NTS, and I think Jeremy made a very kind introduction regarding me, and I would like to thank the IFA Korea for inviting me to this event. It's my privilege and honor. And today, I wanted to share with you some recent trends and developments of the MAP process at NTS. As I bet you all know, the OECD base erosion and profit shifting project has had a significant impact on international taxation and on the actions of the tax authorities as well. Since its inception in 2015, the OECD BEPS deliverables have continuously supplemented the growth of the TP area, and Korea especially is an active country when it comes to adapting OECD guidelines into its domestic tax laws, which I'll be talking about today. Amidst this backdrop, the recent OECD proposal and subsequent revisions to the Korean transfer pricing regulations reflect the broader trends within the OECD BEPS projects. In today's presentation, I will discuss some of the salient points arising from the revisions and actions took by the NTS to make improvements to the procedure. I would like to share with you how the organization is structured at NTS. There are two ministries that deals with the MAP issue, which is MOFA, Ministry of Economic and Finance. They deal with cases concerning the application and interpretation of tax treaties. And at NTS, where I'm working at, we deal with cases concerning taxation, not in accordance with the tax treaty. So we have a dedicated MAP unit, which was established from 2018 from March, which was following the recommendation of the OECD. And we have a CA who is the assistant commissioner, who's my boss for international taxation. And there's a delegated CA who actually manages everything in practice, who is the director of this specialized unit, the mutual agreement procedure director. And there's total of 21 people who is working very hard with one director and 6 deputy directors. They are all divided and they specialize each in different treaties, tax treaties. And each deputy director is responsible for certain tax treaty partners. So this is how we are organized at NTS. So we have a type ship with limited people. They are sometimes overworked and underpaid, but everyone tells me that they are very happy to be on board and proud to be a member of the TP team. They tell me this even when they're not drinking, so I'm believing that it's true. However, you'll be amazed at what we have achieved so far with the limited resources we have. So let's look at the MAP statistics. The recent MAP statistics, I have put this here. These are the numbers only for the cases closed in 2019. I put this result in because it makes NTS look good. The reason for such a short time of closing cases is mostly because of our hard work, but also a lot of luck, because in 2019 we closed the young cases, and it was a very good year. But to get a better picture, I must reveal the results of the peer review results that came out last year. That would be all the cases closed during the statistical reporting period of 2016 and 2018. You won't have a slide here, but I'll because it makes us look a little bit bad. But you can always check it on the OECD site, which reveals all these statistical reportings. Excuse me. The average time needed to close MAP cases during the statistical reporting period, which I said was 16 to 18, was 31.71 months, which can be broken down to 30.5 months for TP cases and about 36 for other cases. So that it's not as good as 2019, but considering the OECD average, we're doing pretty good. So I must admit that Korea has not closed its MAP case during the statistical reporting period within the pursuant 24-month average, which is the OECD recommendation. Both for attribution or allocation cases and other cases are not resolved within this average. The average time to resolve other cases is significantly higher than the TP cases. As you know, those are more difficult. As I told you, on average, Korea took 31.7 months to close MAP cases. This was the result for the second stage peer review process. It is an improvement of the first stage review, which showed an average of 37.6 months, which converts to an average of 40.24 months for TP cases and 29.99 months for other cases. Now you know why I didn't put those data in. Apart from somewhat high average time needed to close MAP cases, Korea's MAP inventory has been continuously decreasing significantly over the years. And considering that TP cases close time for all OECD countries in 2019 was 30.5 months for TP cases, not bad, right? We're really working hard. At the beginning of the statistical reporting period, Korea's MAP inventory pre-2016 MAP cases consisted of 144 and others with 86 TP and others with 86. And at the end of the statistical reporting period, the total inventory of pre-2016 cases has decreased to 56 cases, consisting of 22 TP and 34 other cases. That is a 74 decrease in caseload of all TP cases and 41 decrease in all other cases. So I don't want to bore you with all these statistics, but these are the result of our hard work and effort of our TP team at NTS. So I just wanted to emphasize that each case, it's grueling work and a lot of time and effort that goes in. So please bear with me. But really, let's move on to the recent changes that took place to replace the MAP guidance. We all say, you can switch the slides. It's another, another statistics that that makes us look good. So we always say that the devils are in the details, so please bear with me on what improvements that NTS tried to make. So I'll go step by step and introduce some of the changes that have been taken place at regarding the MAP guidance. So first, I want to introduce you to the calculation of interest, how it changed. Once the tax audit is concluded and the taxpayer decides to appeal the additional tax assessment, the taxpayers may apply for deferral of tax collection or postponement of disposition before filing appeals procedure. However, interest on the tax assessment continues to accrue during the appeals process, as of course, the taxpayer is subject to tax payment deferral interest rate that was really high if payment is deferred by the taxpayer for the duration of the appeals process. It was therefore in the taxpayer's best interest to first pay the additional taxes and penalties before proceeding with the appeals to avoid occurring further interest. So that's not that reasonable. So where the tax payment is deferred by the taxpayer, the new rule stipulates the national tax refund interest rate to be applied for the deferment period after 2 years for MAP. So while this reduces the interest after the 2 years, it should be considered in the context that the targeted average period in South Korea for resolving MAP cases received on or after January 1st, 2016 is 24 months. So please understand. And let's move on to the next one. The filing period has been inscribed into the guidance as well. Even if the treaty does not specify the MAP filing deadline, the guideline specifies that at least a 3-year MAP filing period should be ensured, and the execution of MAP results. In the past, when the taxpayer takes both routes of appeal to court and MAP, if the court ruling differed from the result concluded by the MAP would be deemed not to have proceeded in the first place, so it would have been nullified. The amendment deletes such clause to strengthen the effectiveness of MAP and to deter unnecessary court appeals. Furthermore, the taxpayer may put forward its position on the MAP to the tax authority until the conclusion of the MAP. And also, for MAPs that are concluded, the TP income adjustment resulting from the MAP is returned within 90 days from the next day following the MAP conclusion date. So these are some improvements that we made. And as you can see, NTS is working hard to improve the process here and there for the taxpayers' rights. And let's move on to the next slide. And we'll see other improvements that were made in last year. The previous transfer pricing regulations stipulated that once the final court decision was rendered, taxpayers could not apply for the commencement of a MAP, and any open MAP cases would automatically be terminated. Under the revised rule, in certain circumstances, taxpayers will be allowed to initiate a MAP, and ongoing MAP cases will not be closed even if the final court has issued a final judgment. This exception will apply where, in response to a primary adjustment made by the tax authority of one contracting country, the tax authority of the other country makes corresponding adjustment with respect to the tax liability of the entity located in that other country. This assessment will strengthen taxpayers' right through a MAP by alleviating conditions for commencement and termination of the MAP. The relevant provisions will be effective for MAP cases that are in progress and the court issues final judgment on or after January 1st, 2021. So it's starting from this year, or if it was submitted to the tax authority on or after January 1st, 2001. We also try to improve the consistency between the court decision and MAP. According to the prior provisions of the LCITA, a taxpayer was allowed to implement MAP and to proceed with judicial tax appeals simultaneously, even if Korea's competent authority of Korea reaches an agreement with the competent authority of the other country contracting state through a MAP. Under this amendment, taxpayers are required to accept the MAP agreement and to withdraw from any judicial appeal proceeding regarding the concerned MAP case as a condition to implement the agreement reached with the other contracting state under the MAP. This relevant provision will be applicable to cases reaching mutual agreement also starting from this year, from January 1st. So what I have to say is that tax assessment in Korea based on transfer pricing are on the rise, and the interpretation and application of the rules of taxation is becoming even more complex and controversial, as you may all know because you are in this practice. Accordingly, disputes on transfer pricing issues are inevitable, and in this situation, many taxpayers are considering the APA as a preemptive transfer pricing risk management tool, as well as filing a map to deal with these difficult transpricing disputes. Of course, the COVID-19 pandemic has resulted in the suspension and delay of inter-country map face-to-face meetings, but and in practice, some countries refuse to hold video conferences due to the confidentiality issues. That's what the other side say. But however, new ways of working, including old-fashioned just teleconferencing and new virtual meetings on a secure line, have been conducted, and we're kind of on track now, and we're getting used to the COVID era. And the Korean government is continuing to improve and update the Korean TP regime and strengthen the effectiveness of MAP here and there in line with the OECD principles. It is also noteworthy that recent legal revisions, such as the arbitration provision in the context of MAP, will improve the process even further. I would slightly touch upon the arbitration under tax treaties that we amended under this ITC Article 43. If the competent authorities are not able to reach an agreement in the MAP within the stipulated time, which is 2 years under the applicable tax treaty, a taxpayer would be allowed to apply for arbitration. As of now, however, no tax treaty that Korea has entered into contains a provision on arbitration. So what is the Korean position? So what the Korean position right now is that there is actually no domestic law limiting the inclusion of MAP arbitration in its tax treaties, but this inclusion of MAP arbitration, however, is not part of the Korea's tax treaty policy at this moment. Korea recently issued MAP guidance stipulates in paragraph 3.7 that MAP arbitration is not provided for its Korean tax treaties. It specifies that. And in the commentary to Article 25 of the OECD MTC, Korea reserved the right not to include. So we opted out on the mandatory arbitration provision on the tax treaties. So that's the current state. We have it in the ITC, but we don't have it in the tax treaty. So what's our way forward? So there are pros and cons of MAP, as you know. There are good things, such as the MAP process. Jeremy, am I okay with the time right now, or am I just... I think okay, yeah. So I'll make it short. So there are advantages of MAP, avoiding double tax efficiently, and we're trying to make it more effective. It removes a lot of issues from the examination team to make it, and it's cost effective in our perspective, and it's flexible. So there are sometimes a roll forward period internally that we look at cases that had successful MAP resolutions, and in subsequent filings that with unexamined tax years, we try to be consistent with our logic. So, but I know that there are some improvements, and some people argue that we need an arbitration, and it is true that in not all cross-border issues that MAP is allowed, such as non-treaty partners or anti-avoidance provisions in domestic laws. So you can just skim through the PPT. So before I go, what I wanted to say as a government panel, I must say that NTS, we are doing our best to improve the MAP process and protect the tax rights. Such improvements are made through continuous recommendations to OECD from NTS to MOFA on the internal regulations and the details. This is on top of our caseload and on top of following new issues and trends on digital tax. If you meet a tax officer who seems a bit cranky, please understand we are trying our best with our limited resource and time. Thank you for listening to another somewhat cranky tax officer. Thank you.
Thank you, Min Kyung. You're the most happy, cranky tax officer I've ever seen. It's a pleasure having you. I'll spare you questions today. Maybe we'll have some time towards the end of our panel, and we'll come back to you with questions. But for now, thank you. Very interesting presentation on MAP and developments. Our next panelist is Bhamik Goda. He's a chartered accountant and partner at BGSS and Associates in India. Prior to founding BGSS and Associates, he worked for 9 years at Ernst & Young. He has substantial experience in business restructuring, international tax, foreign exchange laws, and tax litigations, and he's authored numerous articles on taxation. Today, Bhaumik is going to talk about recent cases and developments in the taxation of software royalties in India and a landmark decision that's recently come out. So I'll turn the mic over to Bhaumik.
Thank you. So the decision on which, or a topic on which I'm going to discuss is a topical one, a decade-old controversy in India, something which recently Supreme Court have settled in the favor of taxpayer, in the favor of assessee. On the next slide, please. The next slide. So what transpired was that various software companies interacting with India, and India in those age where we are speaking, it's a decade-old litigation, 100+ cases up to the apex court, and a final decision from apex court, considering exhaustively 18+ tax treaties, which largely resonates the entire world of international taxation. What was before Supreme Court was a question that whenever an Indian company makes a payment for acquiring software, whether it amounts to royalty, if it amounts to royalty, whether there is any withholding tax implications. Similarly, from a recipient standpoint, whatever income they get from India, whether it is chargeable to tax as royalty. The next slide, please. What was considered by court was 4 typical business model, and this decision is likely to have a far-reaching implication. The result and the end result is in favor of assessing a significant millions of dollars stuck up in litigation, opportunity to get refund along with interest from the Indian Revenue Authority is on the table. There were 4 business models, 4 different type of models which were before Supreme Court. The first one was where a particular software company provides its software directly to the end user. Second is a case where there was an intermediary distributor. Therefore, the NR seller, that is the IP holder, sells this particular software to the Indian distributor, and Indian distributor sells this to the end customer. Considering was an old era decision. Of course, in the subsequent part of the presentation, we will deal with what is the implication of this decision on other kind of models. But it was a case where typically software was transferred to CD disk, which now we don't see in the present era, but somewhere where it was an IP holder who used to sell it to the Indian distributor and then ultimately to the end customer. The third was a case where the reseller, that is the distributor, was a foreign distributor. It was outside India, and that person sold the particular software to the Indian customers in India. The last was a case where a particular software was embedded with hardware. And the question was, when the payments are made for this kind of an hybrid payment, whether this payment attracts any withholding tax in India or not. The next slide, please. What court did was independently came to the same conclusions which are forming part of OECD commentary. Court also observed OECD commentary and agreed to those conclusions on an independent basis. This is very important because even under the OECD commentary, ultimately the taxation of computer software is recognized as a literary work. Ultimately, it has to be governed by the Copyright Act of a domestic law. Court took cognizance of the Copyright Act in India and came to its own conclusion. What was noticed was that in the end user license agreement, there were certain rights which was never alienated by the IP holder. So therefore, the case was across the board that whatever end user license in the end user license agreement, the rights which was given was non-exclusive, non-transferable. The Indian end user cannot sublicense it, cannot modify, cannot distribute the parent code. The Indian end user can use it within its organization. Therefore, if it was told that this is the master license which I am giving you, and you can replicate it like the license for your own organization, that was permitted. but you cannot do the commercial exploitation arising out of this entire product. The right to make copy was only for the purpose of installation and backup purposes. The next slide, please. When we look into the distributor also, similar rights were resonating. The distributor only had a right to sell this product within a territory. So it was not a territorial right which was transferred. This right was not transferable. There was no exclusivity which was there. And again, the rights which was there as part of end user license agreement was also enthroned upon the distributor. That means he could not make any right, title, interest in the property right. Everything went to the IPR holder. The next slide, please. Now, considering all these things, considering all these agreements or all these covenants in the agreement, court first looked into the matter from the Indian Copyright Act perspective. As I told, even OECD commentary requires that the first characterization should originate from the source state and then look into the wordings in the treaty concern. The treaty concern and various treaties which India have entered into, and such is also the predominant treaty which one sees across the board, is that there has to be a right in copyright which has to be transferred from one person to another for the payment to be characterized as copyright. Under the Indian Copyright Act, what the Act provides is that there are certain rights which always exclusively belongs to the IP holder. If those rights, which means right to make duplicate copies, which means right to adopt, which means right to modify, if all those rights exclusively is with the IP holder and some of the rights you give to the end user, then only those cases will amount to a transfer of copyright or something where one can say there is a right to use copyright. Now they say under the Copyright Act, an exclusive or a negative right restricting others from doing is given under there is a statutory backup, there is a statutory provisions which gives IP holder certain individual rights. Now looking into the end user license agreement where no such rights was transferred, there was no transfer of the base right. You cannot modify, you cannot reverse engineer, you cannot change the source code, you cannot do the commercial marketing of the product which you get or the license which you get from the IPR holder. If such was the case, then court said that under the Indian Copyright Act, this does not amount to a right or transfer of copyright or a right to use a copyright, and hence this would not amount to a copyright. Therefore, the old controversy or the way in which various literature always comes up, that there is a distinction between a copyright and a copyrighted product, was the sanctity of which was upheld by the Supreme Court. A very significant ruling. Next slide, please. Next slide, please. Ownership of copyright versus ownership of physical material in which copyright is embedded. Court said that whatever is forming part of end user license agreement are basically restrictive right. Pursuant to those clauses in the agreement, IP owner is protecting its own IP. It does not amount to transfer of any copyright from the IP holder to the end user. Therefore, if merely a person is making use of certain rights, say copying, say making duplicate copies of software, where a master software is given to an enterprise and a right is given that for the purpose of your internal organization, you can make duplicate copy, you can do certain backup, you can do certain storage. Now, those rights are merely rights which enables the end user to use the software effectively. If such are the rights, then it does not amount to a transfer of any rights which would amount to a right to use copyright under the Copyright Act. The next slide, please. Therefore, what we see today is that a court ruling which independently came to the same conclusions which was given by OECD. OECD commentary, the sanctity of OECD commentary was also upheld. Now, because these disputes range from 10 to 15 years vis-a-vis the entire software royalty kind of characterization, it is likely to give rise to significant refunds. So therefore, if there are any companies which were party to litigation, there is an opportunity to rely upon this Supreme Court decision come to a fact-specific conclusion and get the refund to ensure that the characterization is in accordance with the tax treaty in India. So this was broad remarks on this decision. Up to the Jeremy for his concluding remarks or any questions.
I had a couple questions for you, but before I do that, we've actually got a question from one of the participants that's come through, and you're the first lucky panelist to receive one of those questions. So I'll go with that, and we'll get your response.
Sure.
The question is payment for software use training regarded as either royalty or business profits in India?
Is payment for software?
The payment, it says, for software use training.
I think so the question needs to be broken in two parts at this moment. What participant intends is that there is some training which is provided for the purpose of usage of software. Okay. Now, if this training is integral to the supply of software, say a particular ERP software is given by an IP holder, a right to use to an Indian consumer. As part of it, if there is an onboarding training which has to take place, it will partake the same character as the main software. But if it is some additional training which is provided, which is independent of supply of software, then one will have to look at the tax treaties. If the tax treaties are a traditional tax treaty where only technical services are taxed without anything more, this may result in Indian taxation. One. If there are certain clauses like a make available clause where there has to be a complete transmission of knowledge from the training provider to the end user, then further fact-specific exercise has to be done, whether it was a generic training or it was always meant that whatever was known to the training provider, he has to imbibe the end user with those skill sets and qualification. If such is the text, then again it may be taxable. A bit fact-specific. We can come to the other questions.
Thank you very much. I'm sure the person who asked that question is pleased. Next question is, do you think this decision is valid for new software models as well, including software as a service?
Right. So therefore, these principles were laid down by Supreme Court in context of an old era of software where a disk was used to transfer a software. But because the covenants and the Copyright Act continues to be the same, if the agreements in terms of the licenses or say a software as service, etc., bear similar terms, the conclusion will apply with equal force. Two important developments which has taken place in India pursuant to the action plan 1 of BEPS. India have unilaterally came up with significant economic presence and equalization levy. Now that provisions in a way extends the territorial boundary of India, and in those cases it may result in taxation. Significant economic presence, if you download a software above say a 2 crore threshold INR or a particular monetary threshold, then in that case it has a tax presence under the domestic law. But of course, sanctity of treaty continues. So if you are ticking the right boxes in terms of MLI, principal purpose test, and are entitled to treaty benefit, your position continues to be same. Equalization levy, that is a unilateral measure. Law says it is not subject to tax treaty. So therefore, there may be some risk on equalization levy. Of course, if at G20 there is some consensus which is reached, India has to make it clear that they will withdraw all these unilateral measures. So that was on the question.
Thank you very much, Bhaumik. I had one other question I had intended to ask, but in the interest of time, maybe we'll push that to the end to see where we stand. Thank you very much. Our next panelist is Eddie An. And Eddie, let me advance the slide. Eddie is a partner at DLA Piper in Sydney. He has over 15 years of experience advising on Australian tax issues, including tax structuring, cross-border transactions, tax consolidation, and stamp duty. He regularly advises inbound and outbound investment funds on the tax implications of their investments, particularly in relation to Australian real estate. Today, Eddie is going to talk about a number of recent transfer pricing international tax cases and developments in Australia, including a landmark TP-related case. TP cases are fairly rare in Australia, as they are also in a number of other Asian countries. And Eddie will discuss this landmark case and the impact that it will have in the future, and also talk about two other important cases addressing the taxation of capital gains and stamp duties on investments in renewable assets. So with that in mind, I'll turn the mic over to Eddie. Welcome.
Thank you. Thank you. Good afternoon, everyone, and thank you to Jeremy for that kind introduction. I'm sad that I can't join you all in person here today, but I am thankful to IFA Korea for this opportunity to speak to you all via webinar. So as mentioned by Jeremy, I will be covering 3 cases today, 1 dealing with transfer pricing and 2 with foreign investment into Australian assets. I hope you find my session of interest and of relevance to you. So the first case is the Glencore decision, which is a transfer pricing case. And Glencore is one of the world's largest natural resources companies. Now, this case was a decision of our full federal court, which is Australia's second highest court for federal matters. And this was a unanimous decision where all 3 judges ruled in favour of the taxpayer. The Australian Tax Office, our ATO, applied to our High Court, which is Australia's highest court, for leave to appeal, but that application was just refused in May this year. So the full federal court decision stands, which is a big win for the taxpayer. And this case, being one of the rare transfer pricing cases in Australia, does provide very useful insight into the court's approach to transfer pricing disputes in Australia. So a quick overview of the facts, which we've summarised in a structure there on the side. So Glencore operated a copper mine in Australia through its Australian subsidiary. That subsidiary then sold 100%, so all of its copper concentrate, to its Swiss parent. Now, initially, that copper was sold under a mine offtake agreement. However, after a few years, from 2007, the parties changed the arrangements to a price sharing agreement. And under these new arrangements, the price for the copper was the official London Metal Exchange price, less, and this is the important part, a fixed 23% deduction for certain treatment and copper refining charges. Now, this can be contrasted to the previous arrangements, where the deductions for these charges were based on certain Japanese and other industry benchmarks, so a floating deduction. So this new arrangement resulted immediately in substantially less taxable income for the Australian subsidiary. So the ATO challenged from a transfer pricing perspective and levied a bit over $200 million Australian of extra tax over the relevant 3-year period. And the ATO challenged under the transfer pricing rules, saying that the price paid under these new arrangements was less than the arm's length commercial price, that 23% fixed deduction was too high. In particular, the ATO argued that, look, arm's length parties would just never have entered into such arrangements, especially since these new arrangements brought significantly less revenue for the Australian party. However, Glencore, the taxpayer, argued, look, that these price sharing arrangements are actually quite common in the market, in the mining and copper industry, and so they are entitled to use such arrangements, even if they aren't as favourable as the previous agreement that was in place. The next slide, please. So the decision, the full court decided in favour of the taxpayer and held that the price under the new arrangements, it was demonstrated to be arm's length by the taxpayer. The court can first of all confirm the position that the transfer pricing rules generally need to be applied to the actual transaction undertaken by the parties. And this comes up in the context because the Commissioner of Taxation in Australia does have the power to reconstruct the transaction for transfer pricing purposes. But that power can only be used in limited circumstances, normally where the form and the substance of the transaction do not meet. And in this case, Glencore was able to evidence that the price sharing agreements are actually used in the market by independent parties, and so that the reconstruction power had no application. Another important point that the court fixed on was that the subjective intention of the parties is not decisive. And what that means here especially is that the new price sharing agreements were substantially less profitable for the Australian subsidiary. But the court held the transfer pricing rules didn't require the parties or the court to review the subjective reasons for the change in the arrangements. Rather, the focus of these rules is on whether, on an objective basis, hypothetical arm's length parties would have entered into such arrangements. That is, hypothetically, would such parties agree to such terms? And then the court held next, well, the answer to this question depends or requires on an analysis of the comparables and market evidence presented by the parties. And based on the evidence provided, the court was satisfied that the taxpayer had sufficiently demonstrated that the pricing was arm's length. Now, there are a number of reasons why, but I think some of the three key reasons that the court focused on was first, as mentioned before, the taxpayer showed that there were comparable pricing agreements actually used in the market. Second, that these comparable contracts showed a range of between 20 to 27% for the cost deductions. And so the 23% rate adopted was right in the middle. Also, there was an annual industry report for copper concentrate called the Brook-Hunt report. And that also provided a range for these types of deductions. And the 23% rate was, again, right in the middle of that range from that industry report. And so Glencore was able to demonstrate to the court that its pricing was arm's length. Next slide, please. Great. So what's important about this decision? Well, as Jeremy mentioned before, transfer pricing cases are rare in Australia. It's been more than 2 years since we had the last transfer pricing case, which was the Chevron case regarding cross-border loans. And before then, only a handful of transfer pricing cases. So Glencore really provides some useful recent judicial guidance on the application of Australia's transfer pricing rules. And one of the key points that came up was that the courts take a very flexible approach towards comparables, especially when compared with the ATO. The court was open to accepting imperfect comparables. So here the court agreed that many of the comparables relied upon by Glencore, they weren't identical, so they were not identical to Glencore's arrangements. And some of the comparables actually had quite material differences. But the court held that they could still be used as valid reference points for determining the arm's length price for Glencore. So this really provides taxpayers with some additional comfort on the wider range of comparables that they can use to support their transfer pricing position. Another key issue arising from this case was the importance of witnesses and expert witnesses. So both, as is normal with transfer pricing disputes, both Glencore and the ATO engaged external market and financial expert witnesses. Now in Australia, in a dispute, independent witnesses are there. They're primarily there to assist the court rather than a particular party. And so it is common, and this was the case here, for the experts from both sides to be required to meet in person, in conference, and prepare a joint report that identifies the key matters that they agree on and disagree on to assist the court's decision-making. And based on this, the court preferred the approach of Glencore's witnesses. The tax office's witnesses had made certain errors in its positions and assumptions. And in fact, one of its key witnesses for a different taxpayer had actually accepted a higher rate of deduction of about 25.5% on a previous transaction. And so they were arguing against their own position that they had put forward in a previous case. So this case really highlights the importance in choosing the right expert witness and including taking into account their prior history as expert witnesses in that area. The other important point raised in this case was the court's approach to limiting the scope of the reconstruction power, which I flagged before. But I do note these reconstruction powers have been expanded in the most recent transfer pricing rules. And so there is the real possibility of the Australian Tax Office still pursuing the use of these powers in a transfer pricing, audit, or dispute. And also, it's important to note that the ATO requires that the potential application of these reconstruction powers, that they actually need to be addressed in any Australian transfer pricing documentation, which is different to OECD requirements for transfer pricing documentation. So in summary, Glencore is a big winner win-win for taxpayers and provides useful guidance on transfer pricing disputes in Australia. Next slide, please. So moving away from transfer pricing and into cases involving foreign investors into Australian assets. The first case I wanted to cover was Greensill, which concerned the sale of shares in an Australian company by a foreign resident, but through an Australian discretionary trust. And that's important because generally foreign residents are exempt from Australian capital gains tax, except where the asset relates to real estate or a permanent establishment in Australia. In this case, the shares in this case weren't such taxable assets. So if the foreign investor had held the shares directly, they would have been exempt from Australian capital gains tax on sale. However, the court held in this case, that capital gains tax exemption for foreign residents does not flow through discretionary trusts and other non-fixed trusts. That CGT exemption only applies where investor holds the asset directly or through certain fixed trusts, such as unit trusts. So because of that structuring, the foreign investor was subject to capital gains tax. So this case is really a timely reminder that foreign residents really need to structure their Australian investments carefully before making their investments, especially where using a trust structure. Next slide, please. And the last case I wanted to cover today was the Spic Snowy Hydro case, which concerns stamp duty, which was payable on the acquisition of a wind farm operator. And it's quite timely because we've seen in Australia real growth in the renewable energy sector, especially with wind and solar. And historically, there's been a lot of uncertainty at law for whether renewable energy assets are land for tax purposes. And especially where those assets are held on leased land, as opposed to land that's owned by the taxpayer. And this characterization as land or not land is very important for both stamp duty and capital gains tax purposes, as well as treaty relief. In this case, the court held that the wind farm assets in question did constitute land. And so because of that, the acquirer of the land assets was subject to stamp duty on the acquisition. So, and stamp duty applies at rates of up to 5.5% or 6% on the gross value. So it's quite substantial. Excuse me. And so this case really provides much more certainty to taxpayers who are investing in renewable assets that those assets are likely to be treated as land assets. But what does that mean? That means that it's more likely that stamp duty will be payable on the acquisition of such renewable energy projects, and that also capital gains tax is likely to be payable without treaty relief on the exit of such investments. So foreign investors need to build in these tax costs into their financial models when they invest into such Australian renewable energy projects. And that brings me to the end of my section today. Thank you for listening.
Thank you very much, Eddie. It was very interesting. I think everyone will find that. I had some really, really hard questions that I intended to ask you, some hardball questions, but you're off the hook today because in the interest of time, we're going to move on to our final panelist. And if our final panelist has a really short presentation, perhaps we'll come back to you with the hardball questions, but thank you very much. Our final panelist, last but certainly not least, Anand Raj, I'm sure is known to most all of you, if not all, because he was the former chair of IFA's Malaysia branch. He's a partner at Sheeran, Delamore and Company, over 25 years of tax experience. Practice areas include all aspects of tax and transfer pricing disputes and litigation, as well as competition law and antitrust. He's been recognized as one of Malaysia's top lawyers by Asia Business Law Journal, International Tax Review, Asia Leading Lawyers, Legal 500, and Who's Who Legal. He's the chair of the tax committee of the Malaysian bar, and I also already mentioned that he's formerly the chair of IFA's Malaysian branch. Today he's going to be talking about recent tax dispute trends and landmark cases in Malaysia, including important cases that reinforce privilege and personal data protection rights. Anand will also discuss the use of virtual hearings to resolve cases in Malaysia during the pandemic. So, a lot to cover there. The remainder of the time is yours, Anand.
Thanks, Jeremy. I'd like to thank IFA Korea for inviting me to speak on this panel. And also, it's been great to share the panel with distinguished speakers from around the region. And to all my friends in the broader IFA family, it's great to connect with you again online, and I hope it's not too long before we can get to meet in person. So Jeremy, if you could perhaps display the slides. Thank you. So this is a case that I'm handling for the Malaysian bar, of course, on a pro bono basis, because the bar is our regulator. What happened is in Malaysia, the revenue decided that they would go and knock on the doors of law firms and try to take away information relating to our clients' accounts. So, of course, Malaysian lawyers do pay tax, and we are not exempt from tax. So if they were to come after us and ask for information relating to our office accounts, then we would be obliged to give that to them. But the problem is they started to then stray away from that and started to ask for information relating to clients' accounts, and even then on a broad and sweeping basis. So in common law jurisdictions, particularly in the Commonwealth, obviously it's well known that legal professional privilege is a sacred pillar of our administration of justice. And we've found that in other jurisdictions, the revenue have attempted to knock on the doors of law firms to get specific information in relation to specific taxpayers. And in all those jurisdictions, when the law firms in question denied access to the revenue, the courts did rule in favor of privilege and the protection of privilege. What is interesting about the Malaysian experience is that they've not come to us in respect of individual taxpayers. I mean, they might do that as well, but this case is a situation where they wanted to go on fishing expeditions, walk up to law firms and take all information away relating to all clients' accounts. And among the arguments that they came up with were that the information in clients' accounts, that's not client communication. That's not communication with your client. Therefore, it should not be subject to privilege. And then they've also relied on general provisions in the income tax legislation. So our position has been, look, this is never going to be a case where you're only going to get information in relation to clients' accounts and numbers and stop there, even if privilege is given a narrower definition. The revenue is certainly going to ask, what is this amount for? Who are you holding it for? Why are you holding it? How long have you been holding it? And stuff like that. So that's obviously going to be in violation of privilege. So it got to a head and we had no choice, but we had to take on, Malaysian bar is generally a rather irreverent regulator. Whenever anyone, in our view, crosses the line, we would certainly refer the matter to the Malaysian courts. We've got a fairly robust litigation and judicial structure. So in this instance, we went to court and we took the revenue to court to get the court's intervention to declare that privilege is sacrosanct and that we should not be asked to give away information relating to clients' accounts. And in Malaysia, in keeping with Malaysian case law, the High Court in this case affirmed that, the High Court and the Court of Appeal affirmed that privilege is a rule of fundamental justice and is absolute. I mean, those are the words in red in the second bullet there. It's a rule of fundamental justice and is absolute unless waived by the client. And this is in keeping with a whole line of case law that goes back to Bird and Lovelace in the 16th century in the UK. So being a common law jurisdiction, being part of the Commonwealth, privilege is very heavily entrenched in Malaysian law. And the reason for privilege, I know that not all jurisdictions recognize legal professional privilege, but the reason for privilege is so that clients, and it's not just for tax cases, it's across the board, it's so that clients can approach law firms and lawyers and be completely candid and completely frank with their facts so that they can get the best possible advice and defense in court. And so this principle has been around for 500 years, and we were not about to let it go just in relation to tax cases. So the revenue appealed the decision of the High Court to the Court of Appeal. The Court of Appeal affirmed the decision of the High Court, and the revenue are applying to the Federal Court, which is our apex court, the highest court in Malaysia, for leave to appeal against the decision of the Court of Appeal. That is coming up in the next few months, so keep watching the space. In short, the courts have agreed with us that privilege is absolute, and in fact, gave us a very specific order that we, Malaysian lawyers, are under a duty. We are under a duty to reject any request by the revenue for information relating to clients' accounts and client communications generally. So the court has ordered members of the Malaysian bar to reject the revenue's requests. So this was a fairly good outcome in defense of privilege, but the matter is not closed yet, as the revenue are appealing to the Malaysian apex court, which is the Federal Court. So much more can be said about this, but in the interest of time, I'll move on to my next slide. So what naturally flows from the last case is, what about situations not covered by privilege? Are there any other laws out there that may prevent disclosure to the revenue? And one law that comes to mind is the Personal Data Protection Act that we have in Malaysia. Quite a number of jurisdictions have personal data protection legislation. And the GDPR is a very important piece of legislation in the EU. So can the revenue demand, so question, can the revenue walk up to companies and say, give me your entire customer database? Can the revenue walk up to large companies and say, give me your entire customer database, give me your entire database relating to your loyalty programs, give me everything? Can they do that? So this is now in the midst of litigation in Malaysia, and taxpayers, and we are involved in some of this litigation, and taxpayers are taking the position that the revenue should not be allowed access to such sensitive data, personal data, because we have a legislation since 2010 that protects personal data. And while there could be some exceptions, that we should not be giving databases away on a broad basis where the tax authority or any other authority for that matter comes, knocks on our doors and says, give me everything. So the give me everything approach, taxpayers have basically taken the position that is not right. It may be different if the revenue have a specific or another investigation body, the anti-corruption agency and whatnot, have a specific case against a specific individual, and they say that Mr. So-and-so, Mr. X is under audit, I want you to give me information in relation to that person. That may be a distinguishable position. But if the authorities were to come in and say, just on a broad basis, we have a profiling department, we want everything in your database, we don't know who's in there, but we want everything, is that something that a company is obliged to give up? So this is in the midst of litigation, and so just keep watching this space, and we expect to have some judgments out in the near future. So with that, we can move on to the next topic. This relates to the tax treatment of databases. What happens when a company acquires a database or when a company sets up a database? So in this case, CIMB Bank, which is a very large bank in Malaysia, large banking group in Malaysia, and they have a regional presence around Southeast Asia, they acquired another bank. And amongst the assets that they acquired included a core deposit and credit card customer database. So obviously this is an asset, because when you have a database of customers, then you can, within the bounds of the Personal Data Protection Act, resell them with other products and continue to serve them and hope to get more business from them. So obviously that's an asset. So what happened was they claimed capital allowances on the database and treated the database as plant. The revenue disputed this and argued it was not plant, but goodwill. Good news for the taxpayer was that the taxpayer succeeded all the way before the special commissioners unanimously, before the High Court unanimously, and before the Court of Appeal unanimously. So the taxpayer won all the way. And so this is a landmark case because a database can be plant and qualify for capital allowances. This is an important principle that has application beyond Malaysia. Any country that has a similar tax system where capital allowances are given on plant and machinery can rely on this case and the judgment in this case. Unfortunately, in Malaysia, steps have been taken by the revenue to try to reverse the effect of this case through legislation. So through an amendment to the Finance Act, they tried to reverse it in Malaysia. This case was handled by my partners. One observation I would like to make is this case is, it's correct in principle. The fact that Parliament had to step in demonstrates that and confirms that. But this case is of greater application than just Malaysia, because our system is based on the UK system, the system of capital allowances, plant and machinery, that applies to all, or generally to Commonwealth countries who have adopted the same tax system. So this case is an important case that can be adopted in other jurisdictions. So finally, my last slide. So the pandemic has been an interesting experience for all of us. I remember in March of 2020, when we first went into lockdown in Malaysia, we thought it was going to be 14 days only. And when they extended it by another 14 days, we thought, well, gee, this will be over next month. So initially, lawyers in Malaysia were resistant to doing online hearings. When it became clear that the pandemic was here for a little longer than just 2 weeks, we had a different problem. And that problem was our laws weren't yet amended to fully recognize online hearings. But the judiciary swung into action quite quickly and worked together with Parliament to introduce amendments to the Courts of Judicature Act to recognize virtual hearings, I think in the second or third quarter of last year. Since then, it's been full steam ahead for all of us. And virtual hearings, I feel, are here to stay. And the only problem that we have is with trial work, because with trials, you have to have witnesses, and it's difficult to have a witness just sitting in his or her home giving evidence virtually, because there's always going to be a concern whether or not there's going to be any surrounding influence when a witness is giving evidence virtually. And in a lockdown, it's not going to be easy to send a supervising solicitor over to a witness's home to try and oversee that. So there are some things that we still need to resolve in relation to trials, but where witnesses are required. But apart from trials, where evidence is given by way of affidavits or depositions, where there are appeals and you don't need witnesses, and it's just between counsel and the court, it's full steam ahead. And we've conducted so many virtual hearings. We started out doing them from the office, not having to travel to court to minimize travel. So the team would sit around with appropriate social distancing, a large table with all the documents, which in a way is not a full virtual hearing because the team is still together in one place. But we've now graduated because Malaysia has gone into a very much more serious and enhanced lockdown over the last month. And in fact, we are now doing hearings in a fashion that I would say is fully virtual, where I don't even have court documents with me. They're all in soft copy. They're all in soft copy. They are on servers. They're parked on my hard drive, and we've got to pull out documents this way and display them, share the screen, and argue cases. But I think I'm encouraged by this. I think this has actually allowed us to move quite quickly. We can have hearings in the north of Malaysia in the morning and do a hearing before the court in the south of Malaysia in the afternoon. Something that's just not possible when we're doing physical hearings. So I think we're here to stay. I've been fortunate that, after 25 years of tax practice, I'm not exactly up to date with all the technology, but it's been a great learning experience. And I'm fortunate that we have a young team and they keep teaching me all sorts of stuff relating to new tech. And this has been great. So a shout out to my team as well. So virtual hearings are here to stay in Malaysia, and I think we're going to be seeing that in other parts of the world as well. And I think that probably brings me right to the end of the session. I think I've just sort of met my time allocation. Thank you, Jeremy.
Thank you very much, Anand. We're right down to the minute, right? Perfect. I hope you found this panel interesting. It seems like Malaysia is very much leading the way in Asia in terms of both, virtual hearings and also cases relating to privilege and data privacy, and we're certainly cheering for you and hoping that in the end the outcome will be favorable. And we have reason to believe that they will be based on your presentation. So if anyone else has further questions to ask our panelists, we're out of time right now, but you can either send the questions by email to IFA or to the individual panelists, reach out to them. I know that they would be pleased to answer your questions. It's now time for our coffee break. We have until 4:50 for that. And then my friend and former colleague, Sean Kong, will lead the fourth and final panel, which I understand is the highlight of the IFA conference. So thank you very much for participating and for your interest, and thanks to all of our panelists in IFA. Thanks.
Thanks, everyone. Thanks, Jeremy.
Mr. Everett and the panelists. So we're almost right on time. So let us take a short break before session 4 and resume at 4:50. Welcome back, everyone, to IFA APAC Webinar Session 4. In Session 4, we'll discuss issues relating to taxation on digital economy and U.S. countermeasures. It will be led by Mr. Sean Kang, a foreign attorney at Kim In Chang. Mr. Kang has been advising taxpayers for almost 10 years after his experiences in IRS. His major practice areas include international tax planning and disputes, as well as counseling high net worth individuals. For those who are participating via Zoom, you may find the link of presentation materials in the chat window. For those who are watching through YouTube, you'll find the material on the right top side with download button. If you have any questions or comments, you can use Zoom chatting tool. The moderators will decide which ones to be addressed within the given time frame. So, let me turn the mic over to Mr. Kang.
Thank you, Yeonu. Once again, welcome to Session 4 of IFA Korea APEC Conference. I'm Sean Kang, the moderator of this session. As Yeonu mentioned, in this session we are going to cover one of the most exciting, issues in international tax. That's taxation on digital economy, and we have four esteemed panelists. Let me introduce them one by one. And the first panelist is the Professor Noam Noked. He teaches law at the Chinese University of Hong Kong, and he focuses on tax law and policy. And he has numerous publications and participating in the public forums. Just a couple of interesting aspects of his credential. He used to work as a tax lawyer in the Hong Kong office of Baker McKenzie. And his education, he got BA in accounting and LLB from Tel Aviv University, and LLM and SJD from Harvard Law School. Quite impressive. And the second panelist, Mr. Kyu-dong Kim, he is a tax partner of Yulchon, and he's a co-head of international tax practice at Yulchon. Actually, I'm at Yulchon office here, this Korean law firm. His expertise is in tax consulting, tax controversies, and structuring advisory. And he worked at one of the big accounting firms for many years. And the one interesting aspects of his credential is he is a member of International Tax Advice Group for the NTS, that's Korean tax authorities, and also the Ministry of Economy and Finance, and also a TF member of the Digital Taxation of MOEF. And our third panelist, Mr. Lou Coronado, he is with Ernst & Young Singapore, and he's a partner, and he's the head of the Global Tax Controversy Leader and Global Transfer Pricing Leader, and he worked more than 25 years, and he served before he coming to Asia. He served a lot of multinational companies located in Latin America, and he speaks fluent German. He lived in Germany, and he worked in Tijuana, Mexico City, Amsterdam, Washington, D.C., and Shanghai. And all these panel members' credentials are impeccable. And the last, not the least, Mr. Brandon Brown. He is a partner and head of the tax practice and Maine Wetherell, the New Zealand law firm, and he practiced tax law for many years. I mean, he's been more than 17 years, worked as a tax partner, and he lectured at the Victoria University of Wellington and then University of Ontario. And a couple of interesting characteristics of his credential. He's a member of the Practitioner Council for the New York University International Tax Program, and he's also chair of the New Zealand branch of IFA. Well, we have a lot to cover, so let's just go ahead and then To start, Professor Noket, please take away. I'll turn the slides.
Thanks very much, Sean, and thanks very much to IFA Korea office for organizing the conference. Can you share the slides, please? Yes, so in the next 15 minutes, I will give an overview, just a recap of how did we get here and what are the newest, most recent developments, specifically the statement by the Inclusive Framework from last week, from July 1st, and also what is about to be discussed in 2 days, Friday and Saturday this week, by the G20 in their meeting of the financial ministers and central bank governors. And also what's ahead, what's the timeline for the developments that we expect to take place in the next few months. So we know, and I'm pretty sure that many of you have already been through presentations discussing the challenges of the digital economy, which are summarized by the OECD that certain characteristics create challenges. The characteristics are scale without mass, reliance on intangible assets, and the centrality of data that translate into no physical presence in the jurisdiction where digital businesses or digitalized businesses have sales. And next slide, please. So this has led to the work of the OECD and the Inclusive Framework on the issues and challenges of the digital economy. So the start of it was as part of the BEPS project, and BEPS Action 1 in the BEPS Action reports included a detailed discussion, policy discussion of the digital economy, including various tax measures that were considered but not recommended. But back then it was agreed to continue monitoring and working on this issue with a view of having a report by the end of 2020. In 2018, there was an interim report, and in May 2019, there was an Inclusive Framework agreement on the program of work, which kickstarted the current work on Pillar 1 and Pillar 2, in what we refer to as BEPS 2.0. October last year, the OECD released the Pillar 1 and Pillar 2 blueprints that each one was around 250 pages of detailed outline of how these regimes should work and look like. And the OECD also launched consultation. At the same time, there was an objection by the US to the way that the OECD and the Inclusive Framework envisaged Pillar 1. And a month ago, on June 5th, there was a groundbreaking agreement by the G7 on the outline of Pillar 1 and Pillar 2 on the tax rates, and that's the focus of my next slides. So in July, 1 week ago, the Inclusive Framework, not all of it, but 130 members out of 139 members of the Inclusive Framework agreed to a statement that provides further details beyond the agreement of the G7, but accepts the outlines agreed upon by the G7. In this week, Friday and Saturday, there will be the G20 meeting that is expected to endorse the same proposal and the timeline. And in October this year, we expect to see the agreed framework being published by the OECD with the view of implementing into law in 2022 and starting implementation of Pillar 1 and Pillar 2 in 2023. So as you can see, the timeline is very tight. It's rapidly changing, and the agreements are now being negotiated, as well as the technical implementation detail. Here you can see that various countries have introduced, in the meantime, unilateral tax measures, and the US Trade Representative has launched investigations against these DSTs. Some of the other speakers will provide more information and details about that. Since June, we have tariffs launched by the US, but deferred, suspended until late November 2021 to allow for these negotiations to take place and hopefully conclude before these tariffs kick in so that they can be removed alongside with the DSTs. Next slide, please. The aim of Pillar 1 is appropriate allocation of taxing rights through changes to the nexus and profit allocation rules. And the goal is to ensure that MNEs pay tax in the appropriate jurisdictions, even when they do not have physical presence in a traditional PE in these jurisdictions. And this is done by expanding the taxing rights of market jurisdictions. Next slide, please. The original proposal had more targeted scope, focusing on automated digital services and consumer-facing businesses. And also the plan was to apply it to any CBCR multinational, meaning multinationals that meet the CBCR reporting standard of 750 million euros in consolidated gross revenues. That's in the original proposal. The current proposal that has been agreed is different in a few respects that we're going to mention next. And next slide. The proposal was to have allocation based off of amount A. Amount A is a portion of the M&E's residual profits that should be allocated to market jurisdictions following certain nexus rules. And amount B are the profits attributable to marketing and distribution activities in the market jurisdictions that will also be taxed by them. Next slide. So on June 5th, a month ago, the G7 communique provided a new outline for a proposal which follows the US proposal. And the statement from last week from the inclusive framework provided more information, which is the focus of the next 10 minutes. So the agreed scope provides the following requirements. One is global turnover of over 20 billion euros. So only companies with a global turnover of 20 million euros or above will be within the scope. And this 20 billion threshold may be reduced to 10 billion after 7 years of implementation and 1 year of review. Profitability is also a requirement. The profitability is defined as profit before tax divided by revenue of above 10%. A recent study by Michael Dever and Martin Simler from the Oxford University Center for Business Taxation finds that only 78 of the world's 500 largest companies will be affected by that. And assuming that the allocation will be of amount A would be 20%, we talk about allocation of revenues at around $87 billion. So this is even lower. The numbers of companies affected is even lower than the US proposal to apply Pillar 1 only to 100 companies. So we see here that at least at the start of this regime, it will apply only to a limited number of companies, the largest, the most profitable M&Es. There will be exclusions for extractives and regulated financial services. Next slide, please. So these are the design elements detailed in the statement by the inclusive framework. They provide that the quantum will be 20 to 30%, that's amount A, of the residual profits. These are profits in excess of 10% of revenues. They will be allocated to market jurisdictions based on a revenue-based allocation key. And the revenue will be sourced to jurisdictions based on which jurisdiction is the end market jurisdiction where the goods or the services are being used or consumed. The Nexus rule provides that countries with revenues of at least 1 million euros will be able to claim their share, again, based on the revenue-based allocation key. The tax base, the starting point similar to the original proposal, is the financial accounting income with a small number of adjustments. Segmentation will be available only in exceptional circumstances, and we don't know what these circumstances are. We just know that they will be exceptional. And the segment itself must meet the scope rules. The OECD provides that there will be further work on safe harbors, that there will be a mechanism that will provide for elimination of double taxation of this amount A, either through the exemption method or the credit method, and that there will be mandatory and binding dispute resolution mechanisms regarding double taxation of amount A. Next slide, please. Amount B will be postponed, or the implementation will be postponed to be further considered, and the review will be completed by the end of 2022. And a key point relates to unilateral measures. And there is a statement that this package will provide for appropriate coordination between the application of the new international tax rules and the removal of all digital service taxes and other similar measures on all companies. Not only companies that are within the scope of this new regime, but all companies, meaning that this would likely, if this is agreed and implemented, resolve the clash that we have now between the US and other jurisdictions that have digital service taxes and trade disputes on these issues. The implementation plan, according to the statement by the Inclusive Framework, is that Amount A will be implemented through a multilateral instrument that will be open for signature in 2022. And Amount A will start being taxed and allocated to market jurisdictions in 2023. Next slide, please. Pillar 2, in the interest of time, I'll be very quick, just mentioning the highlights of what are the key developments on Pillar 2. So next slide. What we can see is that the IIR in the GLOBE rules, the tax rates for the GLOBE regime will be at least 15%. That's the rate that has been agreed by the G7 and supported by the Inclusive Framework. There is some objection of some jurisdictions. Among the 9 jurisdictions that did not sign up for the statement, we can find Ireland and Hungary that have a statutory tax rate below that rate. So there might be still a dispute about that rate, but there is apparently a consensus around 15% for the global minimum tax under the income inclusion rule that operates similar to a CFC regime. About the under-tax payment rule, as we know, it's a secondary rule that applies only if there is no jurisdiction applying the IIR. And those of you who have read the details of the UTPR know that it's very complicated, both to design and also to enforce. There is a hint in the statement from last week that there might be deferred implementation as a transitional rule regarding UTPR. So we need to wait and see until October to see if the UTPR is being deferred and until when. The scope will remain the same, the CBCR threshold of 750 million euros, but UPE jurisdictions are free to apply it to multinationals headquartered in their territory, even if they are below that threshold. The STTR, the subject to tax rule, which is a treaty-based rule that applies a nominal tax rate to certain intergroup payments, will be somewhere between 7.5 and 9%. These are the rates that were published a week ago. Next slide, please. Jurisdictional ETR. So we know that generally how it is calculated. We have no further updates beyond what we have already learned in the October blueprints. About carve-outs, the statement from last week provides that there will be formulaic substance carve-outs, excluding an amount of income that is at least 5% or 7.5% in the first 5 years of the carrying value of tangible assets and payroll. One statement in the statement from last week at the end, the last paragraph, may give a hint that there is no consensus yet on carve-outs and what should be the mechanism, because it appears that this is one of the issues that are still to be negotiated and agreed upon by the October deadline. Next slide, please. So the GLOBE rules will have a status of a common approach. It's not a minimum standard, but if a jurisdiction would like to have a global minimum tax, then these rules should be followed. And members of the Inclusive Framework should accept the application of the GLOBE rules by other Inclusive Framework members. There is an interesting and vague comment on the US GILTI coexistence. The statement is that consideration will be given to the condition under which the US GILTI regime will coexist with the GLOBE rules to ensure a level playing field. And in that respect, we can mention the US proposal to apply the US GILTI on a jurisdiction by jurisdiction, country by country basis. But it appears, according to some media reporting, that some countries are skeptical. They want to see US Congress adopts it before they really believe that the US will do that. The implementation timeline is similar to Pillar 1. A detailed implementation plan, together with the remaining issues, will be finalized by October 2021. The statement provides that we should expect GLOBE model rules, STTR model provision, multilateral instruments, and transitional rules. And jurisdictions will adopt, that's according to the current plan, Pillar 2 into their domestic laws in 2022. And this will take effect in 2023. Next slide, please. So what to expect next? We have the meeting in 2 days by the G20, and we expect it to endorse the G7 approach and the statement by the inclusive framework. And we're waiting to see the implementation framework by October. And if all goes well, and there is a consensus, then very likely it will proceed according to the OECD plan as reflected in the statement from last week. We still have a lot of challenges about that. So some of them are short-term, some medium-term, and some long-term. In the short-term, there is still a lot of complexity in drafting the rules, making sure that all of the issues are addressed, and there is an implementation framework ready for implementation by October or by the deadline that the OECD is aspiring to achieve. The implementation itself will be complicated, both for governments and for companies, for multinationals, and some of the other speakers will talk about these issues from the perspective of MNEs that need to handle all of that. Another issue is about countries' reaction to the revenue effects and the scope of Pillar 1 in particular. If Pillar 1 only covers 78 or 100 or a fairly low number, limited number of MNEs, why should governments give up their DSTs on these out-of-scope businesses? And this question might be raised sometime down the road when governments realize that the revenue effects, the tax collected through Pillar 1 and possibly Pillar 2 is fairly modest. Another issue relates to formulary apportionment of M&E profits. So if we accept the principle that market jurisdictions should receive M&E profits by way of formulaic apportionment, why not apply it more broadly? Why only to these largest multinationals, only to excess profits above 10%, and only to part of it, 20 to 30%? So all of these might lead us to further tax reforms down the road that might be the result of this dissatisfaction of jurisdictions. And as we see that in the past several years, the pace of tax reforms has accelerated, that instead of having long periods of stability and occasional changes, we have rapid changes in that regard. So in the interest of time, I will pause here and give the stage back to Sean.
Noam, it's quite an impressive presentation. 500 some pages of OECD material, shrunk into a 15-page presentation. A lot of information to observe. Thank you very much. And next, panelist, Mr. Kim, will cover Korean the digital economy, the taxation of a digital economy in Korea.
Hello, good afternoon. This is Gyudong Kim, and thank you, Sean and Noam, and helpful presentations. Today, I'm going to discuss Korea's reaction to global discussion about digital taxation. I'm planning to cover it in a chronological manner from the issuance of Action 1 report and discussion about unilateral and interim measure and option of Pillar 1 and Pillar 2 blueprints that was October last year, and the latest development G7 agreement and inclusive framework statement issued last week. And I'm gonna focus on the factors Korean government and Korean multinational have considered in responding to these global discussions and how those global discussions have impacted on Korean multinational having operation outside Korea, and foreign multinational having operation in Korea. I believe this discussion will allow us to assess how Korea will react at the time when those final rules to be finalized soon, implemented, and in terms of amending multilateral instrument, renegotiating bilateral agreement, and also amending corporate income tax law and other tax law of Korea. And first slide is about the initial BEPS reaction to BEPS Section 1. Korea is one of the early adopters of electronically supplied service ESS VAT regime. It was introduced almost simultaneously with the issuance of BEPS Section 1 report. That was October 2015. Originally, only certain services like game, video file, and software in the B2C transaction context are covered. But in July 2019, the scope of ESS was expanded to cover cloud computing like Amazon Web Service and online advertisement like Google and Facebook, and online intermediary services like Airbnb and Expedia and Agoda. Next slide. So on the direct tax side, from 2017, Korea and tax authority became quite aggressive in dealing with the ICT M&E, information, communication, and technology M&E. And that's linked with introduction of 2017 tax law, which include expanded scope of permanent establishment rule following multilateral instrument P article. And we've seen number of physical P found based on certain IT equipments and data center and server, which belongs to Korean subsidiary. And agent PE has been found by denying traditional commissioner arrangements. And as a result, we've seen transfer pricing adjustment based on aggressive application of profit split method, traditional cost plus or transfer pricing method using Bailey ratio were rejected by the tax authority. And if P is bound for income tax purposes, the place of business for VAT is found, and there was significant VAT assessment and with significant penalties and interest charge. And intercompany service, if it is export of service, they are generally eligible for zero rate VAT, but Korean tax authority took a position that the recipient service is PE, not the foreign entity, so it's not export services. So they applied the VAT, denying zero rate of VAT. And we've also seen number of payment, service payment, and other payment which are recapitalized as royalty subject to withholding tax. Next slide, please. So if you look at the diagram on your left side is typical example of physical P, and diagram on the right side, typical example of agent P. In conclusion, introduction of BEPS 1 action report had significant impact on Korean tax authorities' assessment practice against ICT multinational, especially US-based ICT multinational. Next slide. As you may recall, in late 2018, there was fierce, intensive discussion with the European Union whether EU-wide digital service should be introduced. If had EU-wide DST been introduced, Korea could have followed European Union, but as you may recall, such discussion was stalled and Korea has not introduced any DST, any interim measure. Korean government is actually cautious about digital service tax and even concerned about digital service tax because the volume of Korean export by domestic ICT companies is actually larger than import by ICT M&E of like US multinationals. And Korea is always concerned about potential trade conflict with US government, and Korean government basically believe DST, which is based on sales, not profits, contradict fundamental principle of corporate income tax on the net profits. So Korea is not gonna adopt any interim measure until OECD finalizes recommendation. We now know the finalization of a recommendation will take place in October this year. Next slide. So now talking about Pillar 1, Pillar 2, and Pillar 1, as mentioned by Noam, is basically relocation of taxable profits to market jurisdictions. And there is no incremental tax liability at M&E level. It is just reallocation within the M&E. And Korean government recently issued a press release, and there are a lot of media report that once Pillar 1 is officially introduced, Korea will be able to assess more on Korean profits of US ICT M&E. Yes, that might be true, but my personal view is such Pillar 1 may not necessarily have a practical impact on Korean revenue arising from foreign M&E. That's because from 2017, Korean government already start allocating higher profits to Korea being market jurisdictions. And the level of profit allocated by Korean tax authority in the recent audit might be arguably higher than the profits that Korea could allocate under Pillar 1. And there will be adverse impact on Korean M&E having significant revenue outside Korea. Korean M&Es are mainly concerned about scope of applications, and Korean M&E is considered as consumer-facing business rather than automated service business, and they believe the scope of consumer-facing business should be narrowed down, and B2B carve-out should be considered. We now know there will be no such distinction. Although we understand there is a chance that B2B carve-out will be included in the final report of OECD in October. And Korean government and Korean M&E strongly advocate the idea of digital differentiation in terms of profitability threshold and relocation percentage, but we now know that's not going to happen. There will be no such distinctions. Pillar 2, as mentioned by Noam, idea of Pillar 2 is basically location chosen for business activities cannot be used to achieve lower tax outcome. My personal view is there will be neutral impact on Korean revenue arising from Korean M&E with significant manufacturing activities in developing countries. It really depends on which method will be introduced. If it is IIR, income inclusion rule, I guess Korea better off. But if it is underpaid, undertaxed payment rule, it should be neutral. On the other hand, there will be adverse impact on Korean M&E, and Korean M&E basically believe formulaic substance-based carve-out, such, for example, certain payroll cost and depreciation expenses of tangible asset should be excluded from scope of Pillar 2. We understand, based on the latest inclusive framework statement, that such carve-out will be included in the final OECD report in October. And Korean government says there is a potential positive impact on the introduction of FDI into Korea. I guess that's on the basis that tax competitiveness of Korea will be better once Pillar 2 is introduced than what it is now. Next slide. And there was actually interesting request that's made by Korean Industry Lobbying Group, FKI, Federation of Korean Industry. They made a specific request to OECD through Business and Industry Advisory Committee. But now they basically says Korean multinational, which is not linked to the digital economy, should be excluded. But we now know such request was not adopted by G7 and inclusive framework. And also they continuously argue that minimum tax rate should be 12.5% or lower. But we now know it is agreed at 15%. And they argue that ordinary manufacturing and investment activity should be excluded, carved out. This is a good, one thing good is this point, ordinary manufacturing and investment activity should be carved out, will be implemented in the final, based on our understanding in the final OECD report. Next slide. The latest development is G7 agreement and inclusive framework consensus and statement which was issued last week. We now know the minimum threshold ratio, which is 20 billion euro, and profitability ratio 10%. Based on various media report, they're gonna be about 70 to 80 multinational globally, subject to Pillar 1. Among Korean multinationals, Samsung Electronics and SK Hynix will be included. And we expect LG and Hyundai Motors will be included in near future. But the latest development is still unclear on carve-out, segmentation, and differentiation rule. The question is, can large Korean multinational M&E be excluded? Well, unfortunately, answer is simply no, because the latest OECD latest inclusive framework statement simply there is no distinction between digital economy and traditional manufacturing business activities. Only distinction is based on the revenue threshold and profitability, the threshold. Next question is, will there be any favorable treatment for Korean multinational? Well, this is something we need to see how it will be reflected in the final report, because we understand there will be certain digital differentiation in terms of formulaic approach of amount A in Pillar 1. For Pillar 2, for Korean multinational, minimum tax rate of 15% is very high, because many of them is currently enjoy tax incentive in Central Europe and developing countries. So this means there will be extra tax payable in those jurisdictions, so there will be extra working capital for foreign investment required. So in the end, for Korean multinationals having significant manufacturing activities in tax favorable jurisdiction, restructuring of overseas supply chain structure will be required. In the latest media report and press release, Korean government says there will be a potential increase of Korean revenue at early stage of Pillar 2 implementation. I understand that's based on, at the early stage, as Noah mentioned, the IIR, income inclusion rule, will be adopted. The final slide. There is interesting development in the OECD, in the US, and Biden tax reform. We can be considered as US countermeasure. This is actually linked to the Pillar 1 and Pillar 2 discussion. And Biden tax reform announced in March, and this is subject to discussion at the US Parliament, and we understand there will be amendment to the original plan, but there will be either modified BEAT, base erosion anti-abuse rule, or introduction of shield, stopping harmful inversion and ending low tax development. If it is modified BIP, there will be increased taxation on base erosion payment. Currently 10%, but we understand it could be 15 or 20%. And if it is shield, there will be no deduction for payment to low tax jurisdiction. Low tax jurisdiction means is linked to the Pillar 2, minimum global tax rate is 15%. Originally, Biden proposal was 21%, but now US and OECD agree on 15%. So these development will, unfortunately, will have adverse impact on Korean M&E with US manufacturing base and global supply chain structure. And in a summit talk between President Moon and President Biden, it was announced Korean multinational will invest more than $30 billion in the US in the next couple of years. and they are planning to relocating manufacturing facility and R&D center to US. But those multinational have subsidiary in low tax jurisdiction like Central Europe and Southeast Asian countries. So we need to see how this Biden reform will affect Korean M&E. Thank you. That's it for my presentation.
Thank you, Kyudong. Thank you very much for your insightful presentation. So next, Mr. Lou Coronado. Lou is going to cover, I believe, India and China and Japan, their digital economy taxation. Thank you. Lou?
Oh, thank you to IFA Korea, and thanks, Sean, for moderating this panel. I will make some comments in general about sort of the rest of Asia, the countries that are not being discussed in detail by the other presenters. I guess, first of all, just remind everyone there's certain exclusions out there, but Philippines is one that actually has voluntarily excluded itself from all of these discussions, right? But if we look at this, I think one could also see it from the perspective of everybody was supposed to be working together as 139, and then you got the Rogue 7, and then you got the Group of 20, and then you've got all this other stuff, right? So are we really working together would be one of the points to bring out, right? And I think the Rogue 7 or the G7, however you want to call them, I think it was heavily influenced by the fact that the US finally gave some signs that they were going to play ball with the new administration. I think that's still positive. That still brings some momentum right now. And we've seen that although there's no written text for law or anything like that, those are just statements up until now of only a few pages or 150 words if you want to count the G7. And therefore, a lot of work needs to be done on how this is eventually going to become proposed law, regulations. And so we know that by October, we should be getting something in more detail after the adoption of the G20 this weekend in Venice of the work and the statement done by the OECD. 2022, you're going to have a lot of work and negotiations and political rallies and so on in the countries to pass this to become legislation. And we're going to see some of this coming into effect in 2023. One of the points to observe is whether we're going to have some countries move ahead beyond the digital services taxes and some unilateral measures on just adopting some of the principles, right? I mean, you would have seen by now, Mexico was ahead of the curve back in the 2015 BEPS, the so-called tequila BEPS. And then right now you've got the underpayment, relatively inclusion already, et cetera, right? So are we going to have some countries out here as well that are going to volunteer and start applying some of these rules? That is something to keep in watch, despite of the fact that it seems 2023 is the kickoff. Some observations in general around Pillar 1 and Amount A. I think segmentation is still of concern. It is public information out there that the European Union has said they're going to go after Amazon, despite of the fact that they have less than 10% operating margin, right, or profits, and that they might go back and segment certain businesses. And obviously that is a major concern. In particular, some China-based companies, they feel that this is cherry picking, right? You might have certain divisions that are profitable, but they are funding the ones that are not so much, or the ones that require more investment for capital or for R&D, etc. So segmentation definitely does have a bit of a cherry picking nature of it. On Amount B, well, there's no signal at the moment on what that outcome might be. Certainly, it is a trade-off for applying this safe harbor for marketing and distribution profits. That I mean, at least now we know it's 2030 over 10% and so on, and some basis for the creation of a taxation right over 1 million euros and so on. We don't have much in Amount B, right? And if you're going to need a number of the developing world to align to this out here in Asia, but also in Africa, South America, and so on, that is something that I think could hold off negotiations a little bit if it's going to be pushed to a separate time. The tax certainty part of it, I think it's probably welcoming for a number of the countries in Asia Pacific, in particular because the tax certainty chapter 9 of Pillar 1, although it hasn't been discussed in detail in the statement, out of the blueprints, it does sound quite promising on focusing on dispute prevention and dispute resolution with a panel mechanism, as opposed to the traditional mandatory binding arbitration that we know a number of countries in Asia, based on sovereignty and other reasons, feel that that is not an alternative that they want to pursue, and that they hopefully these panels are going to be giving a better alternative there. There is a concern, of course, of what happens if we end up with a small amount of companies, and obviously that income doesn't get reflected in the coffers of the governments whilst they're trying to build up their budgets, post-pandemic support, or increase their reserves. Therefore, the EU digital levy and any other sort of digital services taxes still roams out there. How are you going to explain to your taxpaying constituents and communities that you were collecting all this tax for the STs and other unilateral measures, and all of a sudden you give it away because 80 companies are going to pay a bit more tax, right? So that is going to be something that needs to be kept in mind. Are we really going to be able to give away out of digital services taxes or any other unilateral measures? I think another point on if we move on to pillar 2 is that there will be likely a preference in many of the developing world for the under tax non-deductibility rather than the income inclusion, right? And that's just logical because you're going to have less companies within those 80 or whatever number we end up, even if we lower the threshold to 10 billion, that are not going to be based in their locations. So their way to go would be non-deductibility. And again, you've seen already some glimpses of that in countries that have passed some rules about the subject to tax and things like that. On the incentives, that is, of course, something very dear to our region. I think Malaysia, Thailand, Singapore, China, to a degree, they have incentives in various sectors that could be affected. It is promising to hear that there might be a formulaic substance carve out on tangible assets and payroll. Obviously, that is promising. I find it interesting that there is still, if you go to the minutiae, the question as to what did they meant by assets, right? Because I think if you go to the blueprint, it talks about depreciation. If you read the statement, it does talk about carrying value of tangible assets. So is that book value or is that depreciation? That could be a huge amount of difference, either under the 5% or the 7.5% exclusion, that could still allow for companies to continue to invest and to make use of those incentives to stimulate the economics of the locations where they make the investments. So I think that's my summary comments about what we see, at least with our client base and with governments that we speak throughout Asia Pacific on a summary of their concerns of the recent developments of the initiative. Thank you.
All right, thank you, Lou. That was very informative comments. So now, Mr. Brandon Brown, he's going to cover Australia and New Zealand and some U.S. countermeasures for the unilateral measures taken by the other countries. Brandon, please go ahead.
Thank you, Sean. If we could just go to the first slide, if you've got it there. So the topic of my segment is to share with you some experience that New Zealand's had in considering a possible unilateral digital services tax, and then the United States reaction to actual and proposed digital services taxes in New Zealand and elsewhere. And also, for a little bit of context, we'll have a look at what Australia did. And so we start almost 3 years ago, back in 2018, New Zealand had just implemented the first round of its income tax BEPS reforms, and our officials started to think about the possibility of a unilateral digital services tax, having seen that some European countries were looking at those measures. And around that time, as you can see on the slide, in October, Australia launched public consultation on the possibility of an interim unilateral digital services tax. New Zealand followed in February 2019 with a government announcement led by the Prime Minister and Minister of Revenue that we too would consider an interim unilateral digital services tax, and that public consultation would follow. The Australians, though, very soon after that, they moved in a different direction, announcing that in response to submissions, they'd decided not to proceed with a digital services tax, noting concerns about possible double taxation, and also the risks of discouraging competition and burdening the digital sector. And so we had an interesting position where two countries that normally look pretty closely to each other in terms of tax and other policy, quite close trading partners, were taking a different direction. The New Zealand government nonetheless went ahead with its own public consultation on a possible digital services tax. In June 2019, there was quite a detailed discussion document released outlining the design of a possible interim unilateral digital services tax. It was described as interim in the sense that it was meant to be in place of a global solution. And so that discussion document referred to the work that the OECD and Inclusive Framework were doing, but said that there was uncertainty about whether that would progress to a solution, and therefore New Zealand was looking at a possible unilateral digital services tax. In terms of its design, the tax would have been a new tax, separate from our existing income tax and GST, goods and services tax, or VAT. It would apply to certain digital services businesses, and the discussion document gave examples. Intermediation, like Uber, eBay was mentioned, social media platforms, content sharing sites, and search engines. It would exclude companies that didn't have at least 750 million euros of global gross revenues, or companies which didn't have at least 3.5 million New Zealand dollars of revenue from activities that would be within the scope of the digital services tax. Next slide, if we can, Sean. The proposed digital services tax set out in the discussion document raised a number of concerns and issues. One of the key concerns was around compatibility with international obligations. If the tax were a tax on income, it would likely conflict with tax treaties. And remember, this was meant to operate as a unilateral measure, so we couldn't assume that those treaties would be amended. So if it was a tax on income, it would conflict with our tax treaties. If it wasn't a tax on income, there was a concern that it could conflict with our WTO, trade law obligations, in the sense that it might be seen to be designed as discriminating against non-residents. And all of the political statements suggested that that was indeed the intention for this tax to apply to multinationals based outside New Zealand, but participating in the New Zealand economy. And those concerns were taken quite seriously by the New Zealand business community. New Zealand is a country, we're a small country, we're a country which depends on international trade, and we very much value the international rules-based order. So for us to design a tax measure which might conflict with our trade law obligations was something that many commentators and business people were concerned about. Possibly because of those design constraints and the risks of breaching international obligations, the design features of a digital services tax meant that it was quite suboptimal from a tax policy perspective also. It was a tax on gross revenues, not on net income. It wouldn't have been creditable against income tax. That would have meant the potential for double taxation. The tax, although the political statements suggested it was to apply to multinationals and foreign entities, it would have had to potentially apply to New Zealand businesses to reduce the risk that it would be perceived as discriminatory and in breach of our World Trade Organization obligations. Because the DST couldn't be creditable then against income tax, any New Zealand businesses that were caught would face double tax. They would pay their usual income tax on their profits and then the digital services tax in addition. And so we would have effectively this surtax on New Zealand's own digital sector. And of course, you'll recall that one of the reasons Australia cited for not proceeding with its digital services tax proposal was the concern around discouraging the digital sector and innovation. And you can see why when you look at the way this sort of tax would have to be designed. But the business community, as I mentioned, was generally strongly opposed to the digital services tax. Submissions on the discussion documents came from a range of organisations that don't normally participate in tax reform in New Zealand. Organisations like Federated Farmers, which represents our farms who export a lot of produce to the US. You know, they and others were concerned about the impact of this tax if it were introduced on our trading relationships. I've included on the slide some figures about the revenue that was expected to be raised from the DST. And you can see there, the projections were around 20 to 55 million US dollars. And that's a very, very small percentage of New Zealand's total tax revenues. And it's also a very small number compared to, for example, the value of our exports to the US. And so again, you can see why there was that concern from the business community about the collateral damage that could be caused if a unilateral DST were to proceed. If we move to the next slide, we can see then how the United States was reacting to digital services taxes, not just from New Zealand, but from other countries. And I've included there a presidential tweet referring to France, and President Trump there says that he would announce substantial reciprocation on Macron's foolishness if anyone taxes the US technology companies. It should be their home country, the USA. And he concludes by saying, I've always said American wine is better than French wine. He's alluding there obviously to the possibility of substantial tariffs on French wine. And you won't need to decide whether French or American wine is better, because if you're buying wine, you should just go for the New Zealand wine and don't worry about the French and the American. But it wasn't just President Trump, and I think it's important to note that the opposition from the US to these unilateral measures was bipartisan. So both Democrat and Republican representatives and senators were expressing their concerns about unilateral digital services taxes. They were seen as being discriminatory against US tech companies. And that opposition was formalized by way of investigations that were undertaken by the US Trade Representative, which is the body that investigates trade and other practices that are seen as being unfair or discriminatory against US interests, and proposes remedies and retaliatory measures. Those investigations have continued despite the change of administration in the US that occurred in January, although, and I think Noam might have mentioned this, the tariffs that have been imposed have been suspended to allow time for the OECD and G20 negotiations to proceed. Obviously, the US, assuming perhaps that with consensus around at least Pillar 1, these DSTs might fall away, but with the continued threat, I think, from the US that countries that don't withdraw their DSTs might still face these sanctions. Next slide. So just to conclude my comments, by way of summary of what we might see next, particularly in New Zealand, our government has always said that it prefers a global multilateral solution to the issue of taxation of the digital economy, but at the same time has said that it would be prepared to implement a unilateral digital services tax if progress isn't sufficiently speedy. Of course, recent developments already mentioned by other panelists suggest that progress has been made and is being made on Pillar 1. The G7 communique was welcomed by our Minister of Revenue, who again made a very political statement there about the overseas tech giants and the perception that they're not paying enough tax in New Zealand. And so in terms of how we might see Pillars 1 and 2, one assumes that our government would prefer to go with the Pillar 1 solution than the unilateral DST, given the risks I've mentioned that a unilateral DST would pose, including to our own exporters. As for Pillar 2, we haven't seen a formal announcement, but our government is likely to be enthusiastic about that as well. New Zealand's response to BEPS has generally been to introduce prescriptive, often quite bright line rules into legislation rather than taking new approaches to the enforcement of existing rules. And so I think for that reason, Pillar 2 is likely to be attractive. From the business community's perspective, I think the complexity and associated compliance costs of Pillar 2 is likely to be of concern. So thank you, Sean. That's all I had. And thank you also to IFA Korea for the opportunity to speak to your conference.
All right. Thank you, Brandon. Your very comprehensive and thorough presentation. I checked our chatting board and we don't have any questions from the audience. So if any the panel members have any comments, I encourage that. Noam, Lou, and Kyudong, any closing comments? Well, if you don't have any comments, closing comments, I guess I think this is the first time in many presentations in IFA, we end before the time slot we have. Anyway, so thank you very much for participating and listening to these great comments. And if you have any questions or comments, you can reach out to each individual panel members or to IFA Korea. Thank you.
Thank you very much, Mr. Kang and panelists, for such an insightful thoughts and discussions. We are finally at the end of the 2 days event. And again, thank you very much to the audience as well as panelists for your precious time and participation. It was such an interesting and helpful sessions. So we wish you and your family happiness and safety until our next IFA conference. Thank you very much.